Welcome to the Deep Dive. Today we're looking at California tenants' rights specifically, understanding your rights when moving out.
It's a big one. Moving's stressful enough without worrying about landlord issues.
Absolutely. And we're digging into the official California Tenants, a guide to residential tenants and landlords' rights and responsibilities, published by the Department of Real Estate.
Right, a really solid resource.
The goal today is pretty simple. Cut through the legal jargon and give you, the tenant, a clear picture of what you need to do and what protections you have when your lease is ending.
Yeah, things like giving notice, the condition of the place, and of course, getting that security deposit back.
Exactly. And just a note, this is all focused on tenant rights. If you're facing complex issues like eviction, especially in Orange County, Riverside, San Diego, or Los Angeles, getting specific legal advice is key.
That's definitely true. And for folks in those areas needing help specifically with tenant-side eviction defense or unlawful detainer issues, MartinezLawCenter.com is a resource focused entirely on representing tenants.
Great point. Okay, let's jump in. First step. Telling the landlord you're leaving. How does giving notice work?
Okay, so it really depends on your rental agreement type. If you're month to month, or maybe week to week, that's called a periodic tenancy.
Right.
For those, you, the tenant, have to give the landlord written notice. The key is the timing matches the rental period. So month to month.
Yeah.
30 days written notice.
Okay, 30 days.
Week to week, it's 7 days written notice. And this is interesting. You have to give this notice even if your landlord already gave you a longer notice, like 60 days, to end the tenancy.
Wait, really? So if they give me 60 days, but I find a place faster and I'm ready to go in 30, I still need to give my own separate 30-day written notice?
You got it. Your obligation is tied to that rental period payment. The landlord's longer notice doesn't cancel out your notice requirement if you're leaving sooner based on the rental term.
Huh, good to know. What about fixed-term leases, like a year lease?
Generally, those just end on the date specified in the lease. Simple as that. But, always read your lease carefully. Some might have specific clauses about move-out procedures or breaking the lease early.
And what if there was no written lease? Just, a verbal agreement. Does notice still have to be in writing?
Yes, 100%. Even with an oral agreement, California law requires the tenant's notice to vacate for a periodic tenancy to be in writing. It just prevents so many headaches down the line. Always get it in writing.
Okay, makes sense. So notice is given. Now I'm packing up. What about the condition of the apartment or house? What am I responsible for versus the landlord?
This touches on a fundamental landlord duty, providing a habitable place.
Mm-hmm.
Landlords legally have to maintain the property in a livable condition. That includes making repairs for significant defects you reported during your tenancy.
Like a leaky roof or no heat?
Exactly. Habitability issues. And here's a critical point for move out. They cannot deduct money from your security deposit to fix problems that already existed when you moved in or problems that fall under their general maintenance duty for habitability.
Okay, that's important. But what if repairs are needed while I'm still there, things the landlord should fix, but they're dragging their feet? What can I do before I move out?
Right, so the DRE guide outlines a few options. First step, always put your repair request in writing. Be specific, date it, keep a copy.
Document everything.
Absolutely. And if it seriously affects safety, sanitation highlight that urgency. Now, if the landlord doesn't respond or act within a reasonable time, the guide suggests maybe 30 days, but it could be less for urgent stuff.
Yeah.
You might have other options, but tread carefully here.
Like the repair and deduct thing.
Yeah, that's one. If it's a necessary habitability repair the landlord failed to make after proper written notice and reasonable time, you could potentially pay for it yourself and deduct the cost from the next month's rent.
But there are catches, right?
Big time. You have to follow the procedure exactly. Proper notice, reasonable cost, provide receipts. It's risky if you misstep. Honestly, getting legal advice before doing repair and deduct is strongly recommended.
Okay. What about withholding rent? Can I just stop paying if the place is falling apart?
Well, the guide mentions that for major habitability defects, you might legally withhold rent potentially 1 month's worth, but only if the landlord hasn't started repairs within 30 days of your written notice, and you're completely up to date on all other rent.
That sounds risky too.
It is very risky. The guide strongly advises putting any withheld rent into an escrow account to show you intend to pay once repairs are done. Again, this is definitely territory where you want legal counsel first. You can also file complaints with local housing authorities.
Good to know there are options, even if they require caution. Okay, fast forward. I'm almost packed, ready to leave. What about doing a final walkthrough with the landlord?
We'll definitely do that. The guide highly recommends it. Walk through the unit together, landlord and tenant.
Why is that so important?
It's your chance to document the condition together. Take photos, make notes, maybe even video. This creates a record that can protect you if the landlord later tries to charge you for damages that weren't your fault.
Okay.
And even better, California law gives you the right to request an initial inspection about 2 weeks before you move out.
Oh, what's the point of that?
It lets the landlord point out anything they might deduct for, like, say, a stain on the carpet or a hole in the wall. This gives you a chance to fix those things yourself before the final move out, potentially saving you money from your deposit.
That's actually really smart. Avoid surprises. Okay, let's get to the security deposit itself. What can a landlord legally take money out for?
The law is pretty clear here. Landlords can use the deposit for a few specific things, covering unpaid rent if you didn't give proper notice or follow lease terms,
Right.
paying any unpaid utility charges or other specific money owed under the lease, repairing damages caused by you or your guests or pets.
Okay, damages.
Yes, but, and this is crucial, not for normal wear and tear. We can talk more about what that means.
Yeah, let's definitely circle back to that. What else?
They can use it for cleaning, but only to get the unit back to the same level of cleanliness it was when you moved in. And only if needed. And assuming you didn't already pay a separate non-refundable cleaning fee, which are generally not allowed anyway for basic cleaning.
Correct.
And finally, paying to undo any alterations you made to the property without permission.
So they can't just decide to upgrade the kitchen faucet on my dime, or like repaint just because it's been 2 years.
Exactly. Pre-existing issues are out. And normal wear and tear is the landlord's cost of doing business, essentially, not the tenant's deposit responsibility.
Okay, so I've moved out, hopefully left the place in good shape. When do I get my deposit back? And how?
There's a strict deadline. The landlord has exactly 21 calendar days after you've moved out and returned the keys to send you either your full deposit back or an itemized statement explaining any deductions.
Itemized statement.
Yes, it has to list each deduction specifically. And if they did work, they generally need to include copies of invoices or receipts for those charges. There are small exceptions, like if total deductions are under $125, or if you specifically waive your right to get receipts after they've given you notice about it.
So mark 21 days on the calendar.
Definitely. If they're charging for materials they buy often, like cleaning supplies, they still need to reasonably document the cost. It's about transparency.
What if the repairs legitimately take longer than 21 days? Like they need a special part or something?
Good question. If they can't finish the repairs and get final bills within 21 days, they must send you a good faith estimate of the charges within that 21-day window. Then they have another 14 calendar days after the work is actually completed to send you the final itemized statement, receipts, and any remaining refund.
Okay, so there's a process even for delays. What if the landlord just ghosts me, doesn't send the statement, doesn't send the money within 21 days?
Well, that's a violation of the law.
Yeah.
The guide points out there can be penalties. If you have to sue them and a court finds the landlord kept your deposit in bad faith, meaning intentionally and unfairly, you could be awarded not just the deposit amount owed, but also damages up to twice the amount of the deposit.
Wow, okay. So real consequences.
Yes, it provides significant leverage for tenants whose deposits are wrongfully withheld.
So if I think my landlord took too much or charged for something they shouldn't have, what's my first step?
Try talking to them first, or, send a clear letter explaining why you disagree with the deductions, referencing your move-out photos or the initial inspection list if you have one. Sometimes it's just a misunderstanding.
And if that doesn't work?
Then your main option is California Small Claims Court. You can sue for the amount you believe you're owed up to the court's limit, which is currently $12,500.
Do I need a lawyer for that?
Generally, no. Lawyers usually aren't allowed to represent parties in small claims. It's designed to be accessible. Filing fees are relatively low. And remember that evidence. Your photos, videos, notes from the walkthrough. That's gold in small claims court.
Okay. Let's go back to normal wear and tear. That seems like a gray area. Can you give more examples?
Sure. Think of it as the minor gradual decline that happens from just living normally in a place. So maybe some late scuff marks on the walls where furniture was.
Right.
Or like pinholes from hanging pictures, carpet getting a bit worn in the main walkway, faded paint due to sunlight, maybe cabinet knobs getting a little loose, that kind of stuff.
So things that happen over time with regular use.
Exactly. The landlord generally can't charge your deposit for fixing those things. Repainting is a common one. The DRE guide actually provides a guideline. Generally, after a tenant has lived there for 2 years, the landlord shouldn't charge them for the cost of repainting interior walls, regardless of minor marks. It's considered part of the turnover cost.
2 years. Okay, that's a helpful benchmark.
Yeah, for shorter tenancies, if there's actual damage beyond normal wear, like big holes or drawings on the wall, they might charge a prorated amount for painting, but not just for routine repainting due to normal use.
Got it. Okay, shifting gears slightly. What if, in the chaos of moving, I accidentally leave some things behind, like a box in the closet or something on the patio?
Abandoned personal property. California has specific laws for that, too. Civil Code sections 1983 to 1989. The landlord can't just toss your stuff or keep it.
What do they have to do?
They need to give you formal written notice. It has to describe the items left behind, tell you where you can pick them up, and give you a deadline. Usually 15 days if mailed, or 18 if you pick it up yourself.
And they have to store it.
Yes, they have to store it reasonably safely during that notice period. If you don't claim it by the deadline, depending on the value, they might be able to keep it, sell it, or dispose of it, but they have to follow the legal steps precisely.
Okay, so lots of rules to protect tenants. But disputes happen. If things really go south with a landlord over moving out, the deposit, or maybe even an eviction threat, where can tenants turn for help?
Seeking legal help is really crucial in those moments, especially if you get any kind of eviction notice. Time is critical there.
Right, you mentioned that earlier.
Yeah, you typically only have 5 days to file a legal response to an eviction lawsuit, an unlawful detainer. Missing that deadline can mean losing by default.
Wow, 5 days is fast.
It is. So resources. There are many nonprofit legal aid societies and tenant rights clinics across California. Groups like the Housing Rights Center in LA, Public Law Center in Orange County. Tenants together, statewide, they often offer free or low-cost help.
Okay.
lawhillca.org is a great website to find local legal aid. The California State Bar website can help find attorneys too.
And for tenants specifically in the Southern California areas we mentioned?
Right, for tenants needing assistance with eviction defense, unlawful detainer actions, or related issues in Orange County, Riverside, San Diego, or Los Angeles, MartinezLawCenter.com is focused specifically on representing tenants in those situations. That's our specialty.
Good to have specialized resources.
Definitely. Knowing who focuses on tenant representation can make a big difference.
Well, this has been incredibly informative. It really feels like knowing these rights about notice, the property condition, the security deposit rules can take a lot of the stress and guesswork out of moving.
It absolutely can. Being informed, communicating clearly, documenting things like the condition of the unit, it empowers you as a tenant.
So the key takeaways seem to be, know your lease type for notice, document property condition before and after, understand the 21-day deposit rule, and don't hesitate to seek help if you run into problems.
Precisely. It's about ensuring a fair process and protecting your money and your rights during that transition.
And again, for listeners wanting more detailed information or needing legal help with tenant rights or eviction defense, specifically in Orange County, Riverside, San Diego, or Los Angeles, you can visit MartinezLawCenter.com or call 714-442-9741.
Remember, moving out should be the start of a new chapter, not a fight over your deposit or living conditions. Being prepared makes all the difference.
So a final thought to leave you with. Based on what we've discussed, what's one step you'll take to make sure your next move out is informed, protected, and maybe even a little less stressful? Thanks for joining us on The Deep Dive.
Call now 714-442-9741. Thank you.